Lori Vallow has a status conference today, but first I think we should start with some of the motions. This is a motion for time to consult with advisory counsel and team during trial. The defendant, Lori Daybell, requests this court to allow time during lunch and other breaks during trial to meet with advisory counsel, as well as her investigator and paralegal. This request is made pursuant to the 4th, 5th, 6th, 14th Amendments of the United States Constitution in order for this defendant to be given a fair trial. It is necessary for this defendant to have time with her team to consult during lunch breaks and the breaks throughout the trial day. The defendant realizes this request would require perhaps an additional detention officer to escort this defendant to and from the legal meeting area. However, it is crucial that this defendant be given the time needed to discuss crucial issues with her team that come up during trial. There were several instances in the last trial where, because of the detention officer's schedule as well as the court schedule, that this defendant was denied access to consult with her defense team. That is a due process violation. I don't think that got brought up in her new trial demands, but maybe that's going to be used in her appeal. This defendant is requesting that the court schedule time for defendant to meet with her team daily at the lunch break and both morning and afternoon recesses. It can be in the attorney legal room, as the courtroom, or wherever this court deems necessary for security purposes. So, thank you, and then it's signed at the end with Lori Daybell. This is a Lori letter. So, the due process part there, I think, is a little bit of a, hey, you do this because I told you to do it, or it's going to be used as a basis for appeal. And I think that's why that's put in there. So there's another one as well, another document we have to talk about. This is the state's final trial management conference pretrial statement. The state, through undersigned counsel, hereby submits its pretrial statement for the above entitled Action. State's pretrial statement lists charges and sentencing range, including any sentence enhancements alleged. Count 1, conspiracy to commit first-degree murder, C1F, dangerous, 10/2/2019, life with possibility of release after 25 years. There's no offer made. They want 12 plus 4 jurors for the alternates. And the list of potential witnesses. These are state witnesses. We have Jason Biggs, David Freer, Tammy Lachik, retired crime scene specialist, Nolan McDermott, Ryan Pillar, Marianne Robb, Patrick Young. Those are all going to be from the Gilbert Police Department. We have the Chandler Police Department, Nathan Duncan, the Mesa Police Department, Vanessa Milk, Lisa Perry, and Emmy Lynn Cepinoso. We also have the Phoenix Police Department, which would be Kyle Mueller, and we have the Department of Public Safety, which is Thomas M. Olzak. Sorry, I'm recording this right when I wake up, so I'm a little slow. Rexburg Police Department, a lot of different departments here. Makes sense, it was a big search. Ray Hermosilla, Federal Bureau of Investigation. We have Nicholas Balance. We have the Drug Enforcement Administration, Thomas D. Miller. Civilians/victims, Robert Anthony Abado Marco, Brandon Boudreau, victim, Elizabeth Jane Collins, Timothy Zane Deloach, Lynette Mendoza, and Dan Moss. We have brief statement of the case to be read by the jury. The state alleges that the days leading up to, including October 2nd, 2019, Lori Vallow Daybell and her brother Alex Cox conspired to commit first-degree murder of Brandon Boudreau, and the state further alleges that Lori Vallow's co-conspirator Alex Cox drove a Jeep that belonged to Lori Vallow from Rexburg, Idaho to Gilbert, Arizona. The state alleges that in the morning of October 2nd, 2019, Alex Cox shot at Brandon Boudreau from the Jeep as Brandon was returning to his house, and then it continues and it lists the actual house, and I'm not going to show that address just in case. I'm assuming they don't live there, but just in case. And the state has identified approximately 22 witnesses of this trial, 5 of which are out of state. And here is the final page. The state has learned that 3 of the witnesses are not available the week of June 2nd to June 6th. Witnesses Timothy Deloach, Timothy Miller and Nicholas Balance are not available to testify until Monday, June 9th. The state believes that the case in chief will take approximately 4 to 5 days. The state believes it will conclude with all available witnesses either Wednesday, June 4th or Thursday, June 5th. For these reasons, the state asked the court to go dark on Friday, June 6th and potentially Thursday, June 5th and resume on June 9th to call the remaining 3 state witnesses. Pending motions, defendant's motion to dismiss for abuse of discretion by Judge Birsky, state's amended 609 motion, state's motion in limine to preclude inadmissible evidence related to Tammy Lachik, and state's request to preclude the media from showing the face of testifying witness. The state hereby moves to strike the state's notice of intent to use defendant's other acts pursuant to Rule 404B. Oh, so they're not wanting to bring in the other case, I guess? That's interesting. That's interesting. And now it's time to talk about the actual court appearance. Shouting and interrupting happened at the Lori Vallow court appearance. So to begin with, Lori says she has a reply for her motion for a new trial, and the state is no longer using Lori Vallow's previous acts. So all that stuff involving Charles that I know a lot of people were hoping would be brought up in this trial, they aren't. Lori says she hasn't had a chance to read over a lot of the things they're going to be talking about today. They ask Lori if she is against the court not showing the face of a witness. Lori asks if they're FBI. He is. And then she asks, he is a relevant witness? Why? The judge explains he made a PowerPoint using Wi-Fi and cellular data. And then Lori isn't objecting to him being obscured. And this is what's so funny, because Lori asked for relevance, right? That's going to be very important later. So the judge rules the media can't show his face. They can just show something else. I'm hoping they show the actual PowerPoint slide. That was kind of, to me, an issue with the media coverage in the first trial, is sometimes things would be up on that screen. And I'm not talking about like autopsy stuff. I'm talking like other things. And they would show the witness, not that screen. So, hey, if they have to show something that's not him, it would make sense to show the screen. Or they'll maybe zoom in on Lori. They discuss something that only becomes relevant if Lori Vallow testifies and that the state has now added her latest conviction. So I believe this is like the same filing we had in the first trial, where it was like, if Lori testifies and we have to impeach her as a witness, we can go over Idaho. Now they're adding in the Charles Vallow case. Lori says she doesn't know the law because she wasn't sentenced for it yet. You're right, Lori, you weren't sentenced, but you were convicted. You're guilty. But yeah, I think this is all for a theoretical Lori Vallow cross-exam. The judge just tables it. If it comes up, she's going to testify, they can talk about it then. State wants to preclude inadmissible evidence involving Tammy Lachik, a evidence scene technician from Gilbert. This is interesting. This is very interesting because we aren't allowed to know why. Something is sealed, and we don't know, but we have some hints, some little inklings because of things discussed in court. Lori says she just saw it as a request. Lori wants Tammy's employment records, emails, and any body cam that is relevant. Now, to me, that sounds like either a crime or they were found to have done something incorrectly in a prior case, and Lori is wanting to bring that in as a way to be like, hey, she screwed up this case too. But the judge says she isn't entitled to those things if it isn't relevant. If she is entitled to information on things that happened 4 years later, so we got a time frame, 4 years after this case, something happened with this woman that is being currently barred from the public eye. We can file your response. Technically, her response is past due. That's a common thing. But the judge gives her until next Wednesday. Lori also objects to it being filed under seal. So whatever this is, Lori is saying she doesn't want it under seal. I think it's just a shame thing, right? She just wants to shame people against her. It's a revenge tour. I get to use that phrase again. There's no reason to not want it under seal to the public unless it's part of your revenge tour, right? Something embarrassing. Defendant's motion for no restraints. Judge calls out Lori, saying in her motion He doesn't know where she got the idea that the recommendation was no restraints. It was always at minimum a rack belt. Lori reads something that says, or have officers on standby, and the judge says, but that wasn't the recommendation. It was an alternative, not the recommendation, right? The judge denies her motion. The rack belt will happen. Last trial, there was one instance where they took a break because Lori had a belt hanging out. Lori asked if the jury was never asked if they noticed, and the judge said there was no request for that. Yes, Lori, you screwed up. And I know I at least saw one juror interview personally that said they didn't know she had the rack belt. Defendant's motion to consult with team during trial. I read that at the start. The judge agrees and adds lunch hour, but in the last trial, they already met during the other breaks. This is important. Remember, we had Lori asking about the relevance of a witness, and we had Lori getting a motion agreed to by the judge. Very important. Very important for what we're about to get into. They talk of the scheduling problem with the witnesses. Judge says dark on the 6th. 5th is going to be up in the air. State says due to Lori listing witnesses, they should screen for the week of 23rd. Lori's expert still hasn't submitted anything to the state. It's already late. Yes. Here we go. So, during the first trial, people argued, right, that she was too slow doing everything, but she's pro se, but it'll be better for the second trial. Even I thought that. But her witnesses are already late. They aren't submitting evidence. She's probably going to have no witnesses again for the second trial due to her own fault. This is wild to me. The judge said it's likely that whatever he does get will be precluded at this point. The judge goes through Lori's witness list: Mr. Dorkin, Weaver Barkman, who's a ballistics expert, Detective Moffat, Jeffrey White, Melanie Gibb, and Zalima Pastinas. The judge asks about Barkman being a ballistics expert. State points out they haven't received anything, so defendant's violation of all rules of criminal procedure are again a problem. And I'm going to say the prosecutor, she had a smile. Trina K had a smile after that. Great. Jeffrey White is her investigator. Lori says she wanted him to investigate the car door and window the bullet supposedly hit, but those two things do not exist. So, to get this, explain what happened here. The judge asked about her investigator. Lori thought he was asking about the ballistics expert. And now she's saying that key pieces of evidence do not exist. So Lori wanted someone to respond to their ballistics. Lori thought he was asking about Weaver. White has interviewed the witnesses, so that's why he's relevant. Next up is Melanie Gibbons and Lima. Lori says she isn't aware of the state interviewing them. The subpoenas are out. Judge asks how are they relevant. Lori doesn't want to answer. The judge says will be precluded unless you can give what makes them relevant. And just saying they are relevant doesn't make them relevant. And at this point, Lori is all fired up. She is yelling. Is this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state? And the judge replies, yeah. The judge keeps repeating varieties of yes while Lori just interrupts him. It is, that's how it works, that's the rule of law. That's Lori saying that, and the judge explains that yes, it is the rule of law. The state does it too. If you can't give relevant information, they are precluded. Remember, literally, earlier, just a couple minutes ago, I said how Lori was questioning the relevance of state witnesses. Lori says they have information with Boudreaux, but the judge says so would a server at a restaurant. Just coming in contact with someone isn't enough. Lori says the state had them on their witness list. Are you saying they aren't relevant? The state does not still have them on the witness list. The judge explains just because they're on a police report doesn't make them relevant. Lori says she needs them to possibly rebut the state's case in chief. The judge says they don't sound relevant, but will include them for jury screening out of an abundance of caution. So he's still kind of letting her off, right? She gets away with so much. The experts that she hasn't turned over reports or testimony, so they are most likely going to be precluded. The trial is likely to end June 13th. June 23rd is being told to the jurors as a possible end date, basically just out of a massive abundance of caution. Lori says, in light of the juror misconduct, or alleged juror misconduct, she objects to so much information going out in the juror questionnaire. And the judge asks, what information? And she doesn't like that it includes her name, Lori Daybell. The judge explains that that's the name of the case. Lori says other trials don't put out questionnaires with the name on it, and the judge says he always has done it. Lori says they will just Google her name and have the same problem as in the previous case, and she does this while shouting over the judge. Very testy. The judge asks, "Are you done? Or are you just going to keep," and does like a hand gesture. "How do we screen if people have heard about you if we don't give them your name?" Lori sits silently. You don't have an answer to that? Lori says, give them her name and they will Google it. Judge says they are instructed to not Google it. And one of the first questions asked is who looked it up, and those people were excused. You have to include the name. Last time over 100 jurors were excused before the in-person for knowing about it. Going over it in person can change the jurors who don't know. If a juror stood up and said, "I know about her Idaho case, and in that case she did blah, blah, blah," that would burn the whole panel. Lori's name will be included in the questionnaire. Lori has no problems with it now. Well, no other problems. Now, at this point, Lori, she's been so quiet, right? No, she's been very loud, very angry. She yells again. "Your Honor, I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send this to master calendar for the scheduling of the trial." The judge asks, "What personal bias is that?" Lori says, "A lot that you showed just now and showed during the trial." The judge doesn't have any personal bias. He says he has over-accommodated you when you have to disclose things. Her expert should be summarily precluded today, but he hasn't done that, which is true. The judge has let her get away with things. Lori says you have denied every single one of my motions since I have been here. The judge says he thinks he was here about 15 minutes ago when he granted her motion to meet with her attorneys during lunch hour. He has granted her motions. Lori says this is the first motion he has granted, and he says, "File motions with a legal basis and I might grant them." Lori says, "Are you saying none of my motions have merit?" The judge says, "Not many, no." Lori says he has denied all of her first team, second team, and her motions. The judge denies that. Lori calls out bias. Lori asks about her previous team's filings. Did they not have merit? And the judge points out that her first team requests to bar the media coverage, which was denied according to law. They asked to have her dressed out during the hearings when they aren't in front of the jury. That was denied according to law. Judge says he ruled on motions according to law. Lori says denied, denied, denied without conclusion of law. Doesn't that show bias and prejudice against one single person? The judge is getting fed up and says, "All right, are you done?" Lori says, "Are you not going to recuse yourself?" The judge says, "No, I'm denying your motion. Anything else?" The judge then says he received a motion to suppress all evidence involving the Jeep Wrangler, a motion to dismiss due to non-preservation of crucial evidence, and that is that for the appearance. But I do want to mention, this is interesting. What the hell do you mean the state doesn't have the part the bullet went into? Am I crazy? My only guess is that they weren't going to originally file charges, so they let Brandon Boudreaux keep the Jeep and he got it fixed or something, right? I guess that, but that sounds like a problem. A problem that I will say that does sound like a key piece of evidence. Not that the state doesn't have more, right? I'm sure they have more, and they have photos and ballistics experts and all sorts of stuff, I'm sure. But the physical evidence being gone, I don't like the sound of that. What I did like today was the sound of the judge finally telling off Lori when she just oversteps. She has gotten away with so much because she's representing herself. So much. And she's questioning the relevance of state witnesses that have relevance, while she doesn't want to explain the relevance of her irrelevant witnesses. She's arguing that no motions get accepted when a motion was just accepted. That's why it's entertaining to watch, but also a reason why I know a lot of you can't watch. A lot of people do not want to listen to her. They can't stand the way she talks, the things she says, her tone of voice, the turn of phrase. They don't like it, and I know that's why some people watch videos like this. And I want to thank you all for watching. I hope you enjoyed. I hope I really captured what happened today. Absolute mess as we expected. I want to know more about the door. I will say that before I recorded this, I did try to do a dive into that expert, that employee, that person they have under seal. There's nothing public. So I don't know if they screwed up another case, or if it's a personal problem, or like an arrest for something they did. And I mean, it's Lori Vallow, right? I could see her being like, well, they got a speeding ticket, and therefore I want that brought up in court. Or they were accused of loitering, and I want that brought up in court. Like, I could see that with her. So we'll probably never know what that is, right? Unless Lori blurts it out in court because it's under seal. I thought she was going to blurt it out today, but she didn't. Again, we'll have to see. And if you want some more stuff, if you haven't covered it yet, my last video is about a case that is very, very fresh, hasn't even made it to the grand jury yet, and it involves sex, a goat, murder, and the Amish. Seems like it's going to be an interesting one.